Today, a Houston woman was charged with murder after she called police and told them that she was taking her dog for a walk late last night in Northwest Harris County and claims a homeless woman approached her aggressively. So she fired one shot, and then she was the one who called police about this, claiming self-defense. But the woman died, and police claim surveillance footage showed the shooting was not justified. Defense attorney Charles Adams making the case that a lot of Texans think they have a right to shoot in self-defense, but many don't realize that right is not as far-reaching as some think.
Using physical violence to defend yourself is narrowly allowed by the law. It's even further restricted when you employ deadly force. The state of Texas does not allow you to use deadly force in response to anything other than an attack with deadly force or a list of crimes, aggravated kidnapping, murder, aggravated assault, certain things that are very limited. If a person is trying to kill someone else, you can act in defense of a third party, but you can't shoot someone for approaching you aggressively or yelling ugly things or even slapping or hitting you.
Is it different than to say, I'm going to kill you?
Not mere words, no. Even if she attacked her physically, but just with hands, it has to be reasonable.
Talk about the difference when it comes to protecting or being on your own property and someone breaking in.
Well, that's a very key difference, right? If someone is breaking into your home, you can use deadly force to defend yourself and your home, period. I mean, this is Texas, right? Here, and I guess we should have said that, she was walking in the parking lot of a grocery store nearby her apartment complex. Public access property is private property, but it most certainly wasn't her property.
If someone does end up in a situation where someone makes them concerned for their safety such that they react, maybe not with lethal force, but physically react, push, shove, and end up hurting that other person, as a defense attorney, what advice would you give for that moment? What should someone do?
When a police officer shoots someone, or a police officer's even present at the incident, they have a right and are given counsel. They're not given, but their union or their police association steps in and makes sure that they have time to speak with a lawyer before they provide a written statement as to what occurred. And that same advice applies to everyone. It is very clear that she believes she acted in self-defense, but most likely she articulated what occurred in a manner that assisted the government in filing the murder charge. Always speak to an attorney, whether you feel like you've done anything wrong or not. If the government wants to question you, assert your Fifth Amendment right against self-incrimination and speak with a lawyer before you give any sort of statement to the government.
So the key takeaways: lethal force is largely limited to defensive property or very limited criminal acts, mostly where lethal force is threatened to be used against you. Lethal force is not automatically allowed just because someone has attacked you with words or non-lethal actions. And as you heard, if you ever hurt someone, justified or otherwise, Charles urges you to plead the Fifth and find an attorney before giving any official statements to police.